Okay, on to our second topic, which is the second largest change really the most recently is July 1st, 2017. We've altered child support. It used to be a strict percentage of the payor's income. Now it is what is called as a income share approach. And what we mean by that was under the Illinois Marriage and Dissolution of Marriage Act, it used to be a straight percentage of normally the father's income. And we'll talk about normal situations here. Usually it's the dad paying the wife for the children for the child support. And so in those situations, if there was one child and the dad's net income, so gross minus deductions, was $50,000, he'd pay 20%. So that's $10,000 of his income that he would pay every year. If there was two children, it was 28%, 3, 32, all the way up to 50. Now the legislators decided that that was a little unequitable. They wanted to take both parties' income into account. So with the income share approach account, they had the Illinois Department of Family and Health Services come up with tables. And these tables determined that based on the parties' joint gross income minus the standard tax deductions, they come out to net adjusted combined income. So they're going to look at whether it's the ex-wife and the ex-husband, or if they were never married, both the mother and the father's income. They're going to say, okay, so maybe they make $100,000 combined. Well, for looking at the table, with the parties that make $100,000 in net combined income, if you have one child, they have to pay X amount in child support. So maybe that's $10,000. Well, then they also look at the proportional share that each party makes. So with that combined net adjusted income, say one party makes $60,000 and the other party makes $40,000. Well, then they're going to have that one party essentially pay 60% of that $10,000 or $6,000. The other party pay 40%, which is $4,000. Now, you're only going to pay if you don't have the child the majority of the time, right? So if the father's making $60,000 out of the $100,000 net combined income, and they have to pay that $6,000, and the mother has the children majority of the time, he does have to pay the $6,000. The mother does not pay the $4,000. That's her portion, but because she has the children, she doesn't have to pay that amount. It's just splitting that $10,000 at a pro rata share. Now, the question becomes, how many overnights does each parent have the children? Because the legislator understands that if the parties are getting closer and closer to having the children overnight and a larger percentage of the time, they are carrying more and more the burden of the daily expenses. So under this statute, once a parent hits over 146 overnights per year, they recalculate the child support. They're going to cross-multiply. It's a very specific and complicated formula that we use, which I don't know if we need to get into now. But essentially, it readjusts what the child support payments are going to be. And it will tend to lower the child support payment for the paying party. And that makes sense. If you're, say your ex-husband only had him every other weekend, one day a week, maybe that's 100 nights per year, but then you start increasing the overnights. He's taking on a larger percentage, a larger proportion of the daily cost and cost to have the children there. You should pay less in child support. Same if a mother's having a child over more and more, and they don't have majority of the parenting time. As you get closer to 50% of the parenting time, the child support amount is going to decrease. And especially once you hit the overnight amount of 146, you have to recalculate the child support, and it will decrease. And that's really essentially the major change with child support at this time. It does also really start to move towards a pro rata share for child-related expenses as well. In fact, the statute makes clear you're supposed to use a pro rata share for daycare expenses. But I do think there's some wiggle room there where judges may be moving towards pro rata share expenses for educational expenses, extracurricular expenses, healthcare expenses for both premiums on medical insurance and unreimbursed medical expenses, as well as any other expenses that the parties might agree to. What I mean by pro rata share, again, is if one party is making 80% of the income and the other party is making 20, maybe that's how you split payment for those expenses. And not all parties are going to move towards that. A lot of people, if they make close to the same income, even if it's not exact, they normally do 50-50. But it is moving towards much more of a pro rata approach, both in child support payments and child-related expenses.